Hi folks, you're with Tacitus today at your Pushback channel. And in this live chat, I'd like to talk about the changing nature of the practice of law and how the new lawyers coming out of college have their heads filled with activism and not the practice of law. In fact, from the ones I speak to, they seem to know so little about the practice of law and the history of law and the evolution and development of law that you'd think they've never been to college at all. All they seem to have learned about is how terribly innocent, angelic George Floyd was treated. They seem to be full of that sort of nonsense. So lawyers coming out, there used to be a certain requirement for lawyers. They had to be reasonably bright. They had to get better marks in their high school graduation, senior high school graduation exam, and there was a certain quality level that lawyers had to meet, or people who wanted to study law had to meet. That's just gone out the window. Now if you look at, say, people like, say, Kim Foxx, the prosecutor in Chicago, now you've got to see, when you listen to her talk and the way she expresses herself, surely she's someone who should have worked in the takeout chicken shop. In fact, she's the Attorney General or the head of the prosecutor's office is insane. But there you go. And so we need to consider that the people going into study law, there's almost no entrance requirement. It's you can go straight in. You can do peace studies law, or gender studies law, or any of these soft African studies law. You can do any of these soft courses and then get through, and you can effectively qualify as a lawyer. Then there's gender quotas and racial quotas and affirmative action quotas, and so they want at least 50% of the lawyers have to be non-white and non-male. So effectively the amount of, if you look at the racial quotas there, only about 12% of the lawyers coming through can be straight white males. That'll give you an idea as to how much things have changed. Now, they're fairly young now, but there's no reason why, with a bit of George Soros funding, some of these activists who maybe have got an IQ of 90 or something, they're going to be prosecutors and district attorneys and attorneys general and all sorts of things. And you wouldn't, again, the only job they're qualified to do is to work in a takeout chicken shop. They can't do anything else. They're too dumb and too stupid, and their heads are filled with activism. Now, the sort of activism that they're filled with is the classic critical race theory stuff. That blacks and minorities have been held down by those evil bad whites, and the whites use the law to do it. So they've even been taught that any form of objectivity in the law is in itself racist and biased against blacks and against black women and lesbians and so on. So we're at a stage now, and it's hard to believe, and as I'm saying it, I think it's hard to believe, we're in a situation now in the Western world where the legal, the lawyers coming out of college don't actually believe in the law. They don't believe in facts. They don't believe in evidence. They don't believe in corroboration. They don't believe in any objectivity at all in the legal system. The legal system must now be a device to correct ideological perceptions of past wrongs and to rebalance what they see as the non-equal outcomes in society today. So the law is now a device to create this artificial ideological equal outcome situation, which is insane. But there you go. Now, if you look at court cases, and there's some high-profile court cases, I'll use the one of Rodney King in Los Angeles quite some years ago now, more than 20 years ago, to sort of kick it off. The way that case was constructed was that the police had to use considerable force to subdue Mr. King, and Mr. King's representatives didn't dispute that. They accepted he'd broken the law. They accepted he'd engaged in criminal conduct. They accepted that he didn't respond to lawful police directions. They accepted that the police needed to subdue him. So none of that was in contention. What they did allege, though, and the judge, in my view, very incorrectly very incorrectly. The Jewish judge allowed them to cross-examine the police officers on the basis of could the reasons they used force against Mr. King, not that they were disputing the need for force, they weren't, but could the reasons they used force be because they harboured some sort of racist intent. Now, very ideological at this point. So these officers were pursued, the police officers were pursued in the witness box on ideological lines purely. Not that they committed a crime or anything like that. So this is where the concept of the hate crime sort of comes in, that you didn't like the guy, and even though you acted lawfully, the reason you acted at all was because you didn't like him rather than he broke the law. So what they do, and if you look at the transcript of the case, they'll switch to facts if they think the facts are suiting. The minute the facts don't suit them or go against them or aren't useful to them, they'll switch to the ideology. You're a racist. You hated him, didn't you? Didn't you? He's just and they use the N-word. He's just an N-word swinging in the trees like a monkey. So so they were baiting the officers with that sort of questioning, a line of questioning. And if that didn't work, then they'd go back to the fact, and then swing back to the ideology. So they formed this sort of hedgehog crisscross pattern to try and box in the police officers. And why the judge allowed this, I've no idea. But the switching from ideology to facts, back to ideology, back to facts, and so on it's a tough gig to go through a cross-examination like that, because you're going from is it yes, no, fact to how did you feel, what thoughts might have been in your head, or what might you believe, and these sorts of things, and of course they're not facts, they can't be proven. If somebody says, well, actually I thought that X, Y, X or Y, that's it, you're a damn racist, therefore what you did is illegal, therefore it's a hate crime, and so on. So ideology has a way of automatically escalating. So if you admit to one, just based on your own say-so, there's no corroborating evidence, it's assumed that whatever you did had that intent behind it, therefore it's this, therefore it's hate, therefore it's criminal, therefore that negates any other hard factual evidence that may have existed. Now, this is how the cases, particularly where there's, say, in gender conflict or racial conflict, this is where they're using the ideology. So they're not disputing facts. They're just saying that there's an ideological reason behind it, which can neither be proven nor disproven. And the only way they can get it is if the person under cross-examined self-incriminates. So that's hardly a standard for going forward. Now, this is something the Soviet courts used. We say that anti-revolutionary bourgeois activities went on the corner of 1st and 2nd Street at 10 o'clock. You were there at somewhere near 10 o'clock. So you engaged in that counter-revolutionary behaviour, therefore you're an enemy of the people, therefore you are this, and therefore we have to put you in prison. So that they need only prove a circumstantial ideological point, and then that escalates right through to where they're in prison. And we see the same sort of tactic used in, say, the January episode, the protests in Washington, where we say it was an insurrection. We say you were there. We say you were near the building at the time. We say you harbored intent. We say you go to prison, you're a criminal. And so they only need proof. They need proof to an incredibly low burden of proof. And they declare that the crime without even having to prove that. They say, well, gee, you were in the city at the time. You must therefore be guilty. We therefore can put you in prison. So this ideological law with and very important here, the automatic escalation. We need only prove that you spat on the sidewalk. And then we know that people who spit on the sidewalk are also Nazis. Therefore, spitting on the sidewalk means you are a Nazi, we can put you in prison. So they play this game, and I don't know why judges allow it to happen. It's quite beyond me. But we need to also realise now that many of the judges that are coming around, particularly in the United States, not all, but many, are also activists. They're drawn from the same pool of people that did their lesbian studies course with a majoring in law. And all this is a course on how to say the law has been racist and oppressive and it has to be changed, has to be turned on its head, all has to be done differently. And when you get a whole generation of lawyers, most 90% of whom believe that that all the law has been oppression and facts don't matter and evidence doesn't matter and this sort of thing, then that's sort of where you head. It's now ideological law has a gravitational pull all of its own. It's dragging the whole concept of jurisprudence along with it. And just a few little things in court that I've noticed. So there's a couple of guys disputing something in court, and one guy looks like he's wealthier than the other, but he looks like he's the innocent party in the dispute. And but the judge says, well, you look like you've got more money than that guy. Why don't you just pay him? Why don't you just give him the money? Why don't you just give them money, hand it over? You look like you're doing all right. What's the problem? And there was the merits of the case were irrelevant. It's just you look like you look like you got a bit of money, so hand it over. So that's and I've seen this in a few situations now where particularly where there's a dispute and that one was probably more class than race necessarily, but where there's race and gender, no, you're the straight white male, just pay it, just give them the money. No, you're the white person, just give the black person them, just do it. Don't come into my court with this, just pay it. So this sort of thing. So there's a lot of pressure now exercised through the courts to make men pay or to make white people pay. And this is something that it's quite arbitrary. Now, you've got the right to appeal it, so you can go to a higher court with a lot of time, a lot of expense, and the amount of money in question may only be $500 or $1,000. So well, you just look, here's the money. It's worth giving it the money away just to avoid the hassle. But that's hardly the point. That's not why the justice system exists. It doesn't exist to rebalance some fantasy of an ideological grievance going back sort of centuries. It's what's here and now and what are the facts. But no, that's not what people have been taught. Now, the other thing is that if I talk to lawyers coming out of law school or even have been out for a few years, they don't know none of the big events that were pivotal in the evolution of the legal system that the West had. And the legal system had the West had the best legal system by country miles. And having done a lot of business around the world, some of the legal systems in other parts of the world, you just gag at the look and say, whoa. And you realise just how well administered, well organised the West used to be. But instead of going on to even greater heights or making sure that the system we have is refined and works for everybody even further, instead we're going backwards. We're going back to this arbitrary medieval law where ideology is the primary issue, and where the facts simply don't matter. There's a big misunderstanding about ancient practices of if the woman sank in the water, she was innocent. If she floated, she was guilty. And there's a big misunderstanding about that. I just want to clear that up while it's in my mind. What the practice was that a priest would bless the water and make it holy water. So it's God's water. Now, if a demon spirit occupied the woman, then the holy water would not allow the demon spirit, would not embrace the demon spirit. So this meant that the accused witch, for example, would float because the blessed water, God's water, would not accept the demon spirit within. However, if the blessed water, if the woman sank into the water, that meant that the blessed water, God's water, was embracing her, and therefore she was innocent. That was why the floating and the sinking issue came about. So it's to do with the blessing of the water, not the sinking or the floating. Now, sometimes they fucked it up. They, for example, sit the witch in a chair that was made of good floaty wood, and so you float on the chair. That's it. You're a demon spirit. Or alternatively, they'd tie someone up, but nobody could swim. Not many people could swim in those days, so the poor woman sinks and goes, she's innocent, but then she can't swim, or she's tied up and no one can jump in to save her, and they've got a rope around her, but someone drops the rope. But there were those sort of crazy things going on. But we're actually going back to, I think we're going back to madness that is akin to that. I think we're losing all the status that the law had as a respected, independent institution that administered facts, evidence, and corroboration, and now we're moving into some era of ideological nonsense that's more suited to the medieval times. You've been with Tacitus today, your Pushback channel, and thank you for listening.